These are the memorials. Nagaboti will start, right? Who's for Nagaboti? You're the Nagaboti.
Your Excellency's permission to approach the dais. Just a moment for settling. Okay. Hello, hello, hello. Yeah, it's okay.
Now that you read the finals, you know the rules. You have 20 minutes for yourself.
Yes, Your Lordship.
You consume all the 20 minutes in the beginning, or you want 2-3 minutes in your rebuttal.
We have reserved 2 minutes for rebuttals, Your Excellency.
So 7 minutes at the end, right? 20 right away, 20 for her, and 5 minutes is the rebuttal time. With that, you want 2 minutes more.
No, Your Excellency, our total time allotment is of 2 minutes for rebuttal, so we are reserving only 2 minutes.
I am telling you, you are 20 minutes,
21 minutes, Your Excellencies.
right?
Yes.
20 to you, her, 20 to you,
Yes, Your
and 5 minutes for the rebuttal at the end,
Yes, Your Excellency.
out of your 45 minutes,
Right.
right? So if you want some time during that time, you may tell us that you will give the rebuttals at that time, and at the 18th minute you can stop, both of you. Thank you.
Okay, Your Excellency.
And then vote it back.
Greetings, Your Excellencies. I am the agent for applicant Nagoya Bhatti, bearing code TC18. I will be engaging this court for 21 minutes, while my co-agent will be doing so for 22 minutes, and we reserve a total of 2 minutes for our rebuttals later on. I am here to present issues 1 and 4 together. With Your Excellencies' permissions, may I please present a brief summary of facts? Thank you, Your Excellencies. Nagoya Bhatti is a Neolithic volcanic island country in the South China Sea with a very large indigenous population that possesses ancient medicinal technologies and abilities like specifically defined as Herboveda in our country. On the other hand, Swazi is a developed state with a large industrial base and developed technologies. Since 2010, Nagoya Bhatti has been witnessing significant climate change and the effects thereof, including reduced fish stock, marine pollution, etc. In 2013, we faced Typhoon Sidra, shortly after which we also faced a massive earthquake, hence causing high amounts of infrastructural damage to the country. In furtherance of the same, we sought for Swazi's aid in this regard. Firstly, to admit our displaced population in the form of refugees for a temporary period of time. And secondly, for them to be able to share their climate mitigation technologies with us so that we ourselves are able to improve the climatic conditions in our country. However, Swazi has implemented immigration safeguards and has refused to share the climate mitigation technologies altogether. Following patent protection claims. Following unsuccessful negotiation attempts, we have now presented ourselves, submitted to the International Court of Justice in their jurisdiction under Article 36, Clause 1 of the ICJ statute, which calls for a compromise. If Your Excellencies are now satisfied, may I please move towards my submissions? The first issue deals with whether Nagoya Bhatti still qualifies as a state under international law. We humbly argue that once statehood is granted under Article 1 of the Montevideo Convention, it is generally presumed that it will continue under international law. Article 1 of the Convention indicates that there are 4 primary requirements to qualify as a state. The same has been elaborated on page 1, paragraph 2 of our written submissions. The 4 qualifications recognized in the eyes of international law are A, a permanent population, B, a defined territory, C, a government, and D, the capacity to enter into relationships with other states. It can be reasonably inferred that at the time of its establishment, Nagoya Bhatti sufficiently fulfilled the requirements of Article 1 of Montevideo Protocol. Further, as per the Namibia advisory opinion, the court has well stated that the legal personality of a state remains despite changes in the administration and effectiveness of the governance. Scholars like Malcolm Shaw, which are significantly referred to in international law principles, also believe that once these conditions of qualification have crystallized, international law itself leans heavily in favor of continuity. Further, a plethora of cases at the International Court of Justice that have been elaborated in paragraphs 4 to 8 of our written submissions have emphasized upon the importance of a legal status rather than a physical existence, and to not take into consideration transient circumstances like temporary socio-political disturbances, etc. Hence, once validity under Montevideo framework is granted, the perpetual continuity is required. Further, we submit that
Sorry, Councillor, I have a question.
Yes, Your Excellency.
Are you saying Montevideo grants the status in perpetuity? Is that your argument?
Your
And
Excellencies,
once granted, it cannot be taken away?
Your Excellencies, while they provide for qualification criteria, a general assumption and international law leans heavily in favor of continuity. It is only in very rare circumstances where extinction may be taken care of, and also extension by consent of states. So our contention here is that on very transient circumstances that are temporary in nature, taking away the statehood of Nagoya Batti would be an overreach that we do not advocate for.
Any precedent in your favor?
Your Excellencies,
Any
please.
precedent in your favor?
Your Excellencies, while various cases have been highlighted in paragraphs 4 to 8, if I may point you towards it. For example,
Let me tell you, these questions are not to demoralize.
I understand.
It is to test you whether at the finals, what should be.
We understand.
See, this kind of things, अभी वो बंद करने का जब हमारा question. See, at times, saying this, it is highlighted in this, at least for me, it may give you negative marking. So better show the judgments if you have precedents. If you don't have, move ahead.
Your Excellencies, if you may please refer to the indicated points. The specific case of Western Sahara advisory opinion that was given in 1975, it was in regards to the Spanish occupation of Western Sahara, and the court held in that particular advisory opinion that while Western Sahara in and of itself qualifies these particular qualifications, and so a perpetuity may be granted to it, the particular transient circumstances may not be taken into consideration. In fact, the legal status is to be given importance to.
Counsel, sorry. What you intend to refer is or impress upon is continuity and not perpetuity. Is my understanding correct? Are you saying perpetuity? Are you saying continuity? Continuity until a particular threshold, right? Until it is withdrawn, right? Or you are arguing perpetuity. I'm sorry, just for my clarification. What's your contention here?
Your Excellencies, while international law leans in favor of continuity,
Yes.
perpetuity plays a very important role in creating a very persuasive argument where it is only in very rare circumstances that extinction may be considered.
Yes.
So in most cases, continuity in this regard is synonymous to perpetuity, unless of course there are external circumstances that may convince the court otherwise.
Okay, okay.
Further, it is particularly argued that the temporary instability of our government cannot be seen as grounds for disqualification as a state. In the case of armed activity on the territory of Congo, which has been reflected on page 4, paragraph 10 and 11, the court has emphasized that sovereignty of a country survives even in the absence of an effective governmental control. The existence of a government is more important than the effectiveness of it, and the same very well exists in Nagoya Batti, without doubt. The same also has been given importance to in the Tinoko arbitration case, elaborated on page 4, paragraph 11.
Page 4 of your paper book.
Yes. Page 4 of our arguments advanced, Your Excellencies.
Sir, serial numbers, not Roman. The Roman pachi.
The first 20 so pages are for it.
Yes, regular pages.
Yes, yes.
Regular pages. Page numbers are foot of the page, sir.
No, 4.
Page 4, sir. Page 4, para 10.
Even jurists have highlighted that governmental displacement that particularly happens due to force majeure reasons does not undermine its status and certainly does not attract disqualification as a state. The same has been even highlighted by prominent jurists like Stephen Tarman. Moving to the second limb of our submissions, where we argue that population displacement and territorial irregularities of a temporary period do not affect the statehood of Nagoya Batti. On page number 5, paragraph 15, in the case of Bosnia and Herzegovina versus Serbia, the ICJ has continued the recognition of Bosnia as a state despite there being mass displacement and fragmentation of the population. This establishes without doubt that temporary relocation of the population or its fragmentation does not disqualify the state from its statehood. Similarly, territory of a state.
How does this case apply to you? Because see, in your case, it is permanent. the displacement is permanent. You will lose your territory in a few years, right? So how do you then rely on this case, right, to make good your submission? Because this case, to our understanding and hearing your arguments, what you're trying to say is that this entire situation is transient, right? But in your case, and correct me if our understanding is wrong, in your case, it is the result is permanent, right? Where you are going to be displaced, your people are going to get displaced permanently, right? Is the understanding correct?
Your Excellencies, in this regard, this is the very reason why Nagoya Bhatti is here in front of the ICJ, with support from developed countries like Swazi, particularly their technology or their temporary aid. We may be able to implement programs and steps that may help us rejuvenate our own environment and climatic conditions to a situation where in the future there may be a situation that we're able to restore Nagoya Bhatti to its original state and form. And so, assuming that this kind of placement of displacement of population is perpetual or permanent in nature would, at this juncture of time, be a little wrong in that sense.
Okay.
We do hope for external assistance through which we can bring back our population and restore Nagoya Bhatti.
Okay.
Further, similarly, territory of a state is dependent upon legal ownership, not the continuous administrative control. Sovereignty in this regard is a legal test, not a physical fact. This has been highlighted in the case of Island of Palma's case. On page number 6, paragraph 17 of our submissions, the Climate Change Advisory Opinion or the 2025 Advisory Opinion on the obligations of state in regard to climate change patently states that uninhabitability or disappearance of territory due to sea level rise does not entail a loss of statehood. This, with direct relevance, proves that Nagoya Bhatti remains a legal state despite there being a temporary territorial loss. Even the 73rd report of the International Law Commission of 2022 states that statehood must be preserved to prevent gaps in international responsibility. Hence, population or territorial loss does not undermine the Nagoya Bhatti's position as a state in international law. In the last...
There is a question.
Yes.
If there is no landmass, you claim statehood over what?
Your Excellencies, in this regard, the landmass currently has not submerged entirely. We do still retain certain levels of territorial land that we may be able to restore our population with. Again, reiterating that this is the very reason why we are in front of the ICJ, to be able to receive support from international community in a way that we are able to restore or go back to a situation where we are able to support our population in the best of its capabilities.
So is your argument not inherently self-contradictory? You are saying that in case if you are given external aid, we might be able to restore our position. If that be the case, then where is the question of moving out or seeking refugee status as on date? How is the cause of action arisen then?
Your Excellencies, the submergence is still happening. However, it's not entirely happened as of now. So, to claim that we have entirely lost our territorial population, territorial object would be wrongful because we do still retain our territory. However, the same currently is unable to, in just these particular circumstances, is unable to support our population the way it used to in the past. And so for a brief period of time, we require assistance so that the population that is not currently being able to be served within Nagoya Bhatti can have a fulfilling life outside of Nagoya Bhatti until we are able to restore it. In the last limb of our arguments in this issue, we seek to establish that Nagoya Bhatti's capability to enter into relationships with international bodies affirms its statehood. On paragraphs 20 and 21 on page 7 of our submissions, the ICJ has affirmed time and again through various cases that external relations operate independently of internal capacity or vulnerabilities and does not waive its capacity to make relations. Even the 2025 advisory opinion that has been referred to calls for interpretations of international law and treaties to happen in such a manner that strictly avoids statelessness or disappearance of state. Since Nagoya Bhatti is still able to make international relations in the form of distress calls that we have sought, or the fact that we are able to represent our country in an international forum like the International Court of Justice, we maintain that we are able to fulfill the criteria of international relations under Montevideo framework and seek to retain our statehood in this regard. The very convincing argument of international relations has been precluded in the respondents' submissions, where they have not addressed this particular criteria and how it is a very convincing argument in support of statehood of Nagoya Batti.
Excuse me, are you signatory to Convention of Refugee 51? Are you signatory to that, your country?
Your Excellencies, we are not signatories to the Refugee Convention in this regard.
What is the effect then?
While the problem of refugees and their status will be argued by my co-agent, the role of Refugee Convention in this regard is to provide a basic ground level definition of what a refugee is for us to be able to further build upon how inclusive refugee definitions can be made out of it. Our intent over here is to establish a baseline through Refugee Convention. However, the same will be elaborately argued upon by my co-agent. Conclusively, if your Excellencies do not have any other questions. Conclusively, Nagoya Batti has fulfilled all criteria under the Article 1 of Montevideo framework, and these conditions need not be continual in nature, so we do continue to fulfill such conditions even now. Further, temporary and changeable circumstances must not affect its standing in the international realm, if only to uphold the principles of fairness and equality under international law.
See, insofar as international relations are concerned, who in your country is representing, the country itself? Your government officials have run away, right? They have found a safe haven elsewhere, right? So they are not in the country. At best, they are a government in exile, right? So they are not in the territory that you are seeking to defend. How are these international relations being maintained? And who is maintaining them?
Your Excellencies, the factual matrix only provides us that only key governmental officials have gone out of the state. That does not mean that the entire administration or governance of the country has collapsed in and of itself. There are still governmental bodies and governmental agents that work within and outside of the country. The very fact that we have been able to appoint agents that can argue on Nagoya Batti's behalf in the International Court of Justice is testament to the efficiency or the very existence of governance within Nagoya Batti.
So it's not your case, Counsel, that government in exile can also enter into international relations. Is it not your case?
It is, Your Excellencies. Government in exiles have in the past proven to be able to sustain relationships in a longer period of time. The very recent example of Bangladesh, where the key governmental figure may be outside of the country, but the government in and of itself was functioning smoothly and was able to undertake legal and administrative work within the country.
Right, please proceed.
If your lordships have no further queries, may I proceed to my next issue? The fourth issue revolves around whether Swazi's refusal to share climate mitigation technologies constitutes a breach of international law principles. Regarding this, our submissions are three-limbed. Firstly, that by virtue of being signatories of the UN framework for Convention on Climate Change, Swazi is liable for certain obligations that it must uphold to ensure compliance. If your lordships, if your excellencies may please move to page 20, paragraph 58 of our submissions. Article 4, clause 1, clause C, subclause C, provides that transfer of technology to the best of one's ability must happen. This particular provision is internationally acclaimed to be a very balanced approach, where it balances the domestic responsibility of a state as well as its international obligations. A reliable authority to interpret Swazi's obligation in this regard is the ICJ advisory opinion on the obligation of state in respect of climate change, which has been elaborated upon on page 21, paragraph 62 of our submissions. The ICJ advisory opinion clearly states that states have an absolute duty of cooperation and due diligence, specifically in situations where irreversible climate harm and existential risk is posed to the affected country, which in this case is Nagoya Batti. Further, in the light of an additional advisory opinion given by the International Tribunal for the Law of Seas, which has been elaborated on page 22, paragraph 68, this particular advisory opinion possesses great persuasive value, and it suggests that states have a strict obligation to assist developing states through scientific and technological means where environmental degradation can result in loss of life and livelihoods. The landmark case of Gabčíkovo-Nadi Maroš, elaborated upon on paragraph 69, the very next paragraph, and its principles have also found reflection in this particular advisory opinion, where apart from obligations of the state, the advisory opinion has also highlighted the results of non-compliance with such obligations that can result in various options. Firstly, cessation of wrongful omission. B, guarantees of non-repetition. And C, full reparation, however may be applicable in the particular case. That Swazi claims protection of, yes.
Sorry, sir.
You say you have been arguing that there were treaty obligations. Are you signatories to those treaties?
To the UN,
Well,
yes, sorry,
I'm not-
sorry, Your Excellencies.
Once you claim the other side is obliged by the treaty conditions, one, have you entered into any obligatory treaty with them in past? If yes, which is that? Second, are you a signatory to any of the international so-called conventions which permit you to seek, what I would say, knowledge of the technologies used to mitigate climate change? Please.
Your Excellencies, in this regard, both the countries are signatories to the UNFCCC, or the Framework on the Convention on Climate Change, and so resulting obligations may arise. As for knowledge of the available technology, the factual matrix stands silent in this regard. However, reasonable inference can be made that such information was publicly available so that Nagoya Bhatti was able to have knowledge of the same.
Sorry, Counsel, so I'll ask you a question with two limbs.
Yes.
See, it is also clear that you have also contributed to the climate change, right? So there is some role that you have also played there. The second fact is that these are all proprietary knowledge, right, which are predominantly subject to national laws. Now, I understand it has been their case from the memorial that this is all subject to domestic laws. What's your stand there? And I particularly refer to the case of Australia versus France, 1974, where it was held that proprietary resources control are all subject to patented tech and domestic laws.
Your Excellencies, in a particular reference to the patent of these technologies, my very next submission on page 21, paragraph 64, the ICJ advisory opinion clearly confirms that intellectual property rights considerations must be logically balanced with the prevention of serious harm, especially in the form of loss of territory, displacement, etc. So while we perceive the fact that domestic patent law protections do exist, in the face of greater risk at a global level that exists, such considerations, certain considerations may be made on part of Swazi, and such patent laws might be bypassed to some extent or to complete extent as may be agreed upon, just so that international peace, cooperation and the battle against climate change can be won over at an international level. So patent protections do exist, but reasonable accommodations must be made.
And how about the fact that you have contributed, if not equally, then to a large extent to the climate change that you are yourself suffering at this stage?
Your Excellencies, Nagoya Bhatti's contribution to climate change has been only in its endeavor to be able to create a better, more industrialized or more developed state. We do understand that there might be certain contributions to the climate change that has occurred. However, the consequences of the same are present and are faced by, the worst of them are being faced by our people. So the actions our actions in the past, while were quite less in quantum as compared to Swazi, should not necessarily influence the decision of providing help and sustenance to the very population of Nagoya Bhatti. On the other hand, Swazi's contribution to this climate impact and the fact that their development in industries and technology was a larger component of such. Your Excellencies, I seek an extension of 2 minutes. The very fact that
I understand where you're going. Sorry,
yes.
sir. Is there a question, sir? Please go ahead. Please go ahead. Sir.
No.
Please go ahead. Sir.
वो तो उन्होंने पूछा ना 2 minutes.
हाँ.
I just said okay.
So, I understand where you're going. See, what's your stand, and very quickly, mindful of the time, what's your stand on Article 27 of the TRIPS agreement?
Your Excellencies, in this regard, both the parties are not signatories to the TRIPS agreement, and so the terms of the TRIPS agreement do not bind us in any regard. However, the particular provisions of patent protections that have been provided upon, as I have already submitted, reasonable accommodations must be made in the interest of larger good and international cooperation amongst countries in general, and the overall well-being of human life.
So is your case that domestic law needs to be tripped in your favor? Domestic law and domestic protection that they are claiming a right to needs to be overlooked in this peculiar facts and circumstances. Is that your case?
Your Excellencies, completely overlooking the patent protections is not a requirement in this case. However, up to the wisdom of the court, if the court may arrive to a decision that can balance both approaches, where patent protections may happen in a manner where assistance may be provided to Nagoya Bhatti, then such a decision would be the best for both scenarios in this regard. Moving on to my next limb, if Your Excellencies do not have questions. Apart from treaty obligations, Swazi also owes a duty of transfer of technology as per customary international law. The requisite conditions of customary international law, that is state practice and opinio juris, have been qualified as has been provided under page 24, paragraph 74. States have consistently and historically undertaken initiatives of climate finance mechanisms, technology sharing arrangements, etc., thus fulfilling the state practice on a historical end, that is the requirement. Also, such practices often arise from binding treaties and agreements that countries have engaged bilaterally or multilaterally that have a legal character in the state's view. They do conform to such obligations with a legal mandate in their minds and not a merely a compliance mechanism, and hence establishing the opinio juris character. The same has been reaffirmed in multiple cases like the pulp mill on the River Uruguay case, where customary international law requires states to employ due diligence of reasonable measure. It has been elaborated on page 23, page para 72, along with reference to other precedent cases.
You still want more time?
May I have 1 minute of an extension? Thank you, Your Excellencies. Even if Swazi denies obligations on the basis of treaty law as well as customary international law, it still owed to aid Nagoya Bhatti to the best of its strength on grounds of humanitarian rights preservation. A variety of principles that we have highlighted on page 24, paragraphs 77 to 79, are treaties that have now taken form of inalienable human rights that Swazi owed to uphold in the interest of justice, order, and global cooperation. Conclusively, Swazi possesses the means and material to aid Nagoya Bhatti substantially. It is a duty conferred upon it, the non-compliance of which must attract international attention and scrutiny, especially in the interest of justice and global peace. I hereby conclude my submissions, Your Excellency. Thank you, Your Excellencies. It was a pleasure arguing in front of you.
If I may just have a minute.
Yeah, please. Stop time. You guys have not started the time yet.
Apologies, Excellencies. Greetings. I will be addressing issue 2 and issue 3. In regards to the second issue, my submission has 3 limbs. If Your Excellencies allow, may I begin my submissions? Thank you, Your Excellencies. The refugee definition in international law is not frozen to the 1951 Convention. Your Excellencies, the Refugee Convention holds a central place when we look at international refugee law. The same has been recognized by declaration of state parties to the Convention. Your Excellencies, the only reason why we mention the convention here is not to argue convention refugees, rather, as my co-agent mentioned, to establish a baseline, and considering the central place that it takes, we must address it, as regional instruments also adopt this definition, although they expand it. However, it is to be noted that the convention is not exhaustive in its application. The same is indicated through the recommendation E of the final acts, which is a part of the preparatory works of the convention, which states that the convention hopes to set value as an example exceeding beyond its contractual scope, guiding states in extending protection beyond its formal confines. I have elaborated the same argument on page 8, para 24 of my written submissions. Regional instruments have also showcased this understanding by expanding the definition. The OAU Convention includes even seriously disturbing the public order, and the Cartagena Declaration includes generalized violence and even disturbing public order. These instruments are being argued to establish an opinio juris before we move on to state practice in the next limb. Moreover, Your Excellencies, international bodies also adopt an evolutionary approach. If I may guide Your Excellencies to page 9, para 27 and 28 of my written submission. Yes,
Are you signatory to the 1969 convention?
Sorry, Your Excellency.
Are you a signatory to the 1969 OAU convention?
No, Your Excellencies. Yes. Moreover, international bodies have also adopted an evolutionary approach in interpreting this definition. If I may guide Your Excellencies to page 9, para 27 and 28 of my written submissions, UNHCR has taken a revolutionary approach, saying environmental harm is not to be looked at narrowly, rather with the impacts that it has, such as state erosion. All this together suggests that the refugee definition is not frozen under international law and is capable of evolution. With regards to this submission, if Your Excellencies do not have any questions, may I proceed with the next one?
Just one.
Yes,
You turn to paragraph 27. You're relying on a judgment where it is stated that the state is unable or unwilling to protect.
Just a second, Your Excellencies.
Fifth line.
Yes. Yes, Your Excellencies.
You are the state.
Yes,
Is it your
Your
case that you are not willing or you are unable?
Your Excellencies, unable to protect is what I would like
You
to
have
emphasize.
abandoned the country and you have left. So how do you express your inability then?
Your Excellencies, for this I would like to guide you to page 11, para 33 of my written submissions. I'll elaborate also. I'm just giving a reference point. When we look at willingness or best, when we try to assess effective protection by a state, it is important that we look at the capacity of the state as well. The willingness or best endeavors are not enough. In our case, we have not abandoned our state. We are still... Yes, Your Excellencies.
34, you're accepting this proposition, which my brother has asked you. You've been going on saying that you are unwilling, or rather you are unable.
Have a look at page paragraph 34, the first line.
Your Excellencies, we are unable to grant.
That
And
is
unwilling
even prior
also.
to the disasters.
Your Excellencies, unwilling or unable is
No,
the
no,
terminology.
I'm not unwilling.
Yes, yes, Your Excellency.
That becomes a tautology with the last word of yours, even prior to your disasters.
Your Excellencies, I'm unable to understand the question posed.
Please read your. Why should the other side
Your Excellency.
accept them when you, as a country, even before the disaster struck, were not willing to give them protection?
Basically, if you have yourself created a situation where your citizens feel orphaned, why should somebody else take care of them?
Your Excellencies, if we look at refugee law in general, refugees mostly flee, in all situations flee their country when the state is either persecuting them or there's some harm from the state. In this case, since we are not following the traditional definition, we are arguing for evolution. In this case, we will look at state incapacity or state we are unable to provide protection in this case. The advisory opinion focuses on this, and that is why we are arguing the fact that as refugee law is understood, since we are unable to protect them, that's why we seek refuge with Swazi, who is a developed nation and is in a much more better condition than us to extend such protection. Can I?
So,
yes.
so essentially what you're saying is that, that you are not unwilling, you are just unable to do it. Is that your submission?
Yes, Your Excellencies.
So, yeah, sorry, ma'am, please go ahead, please go ahead.
The text is clearly indicating unwilling and
That's correct, that's correct. So your text essentially, it says you are both unwilling and unable, right? So therefore this questioning, from the bench. Now, essentially, see, since there is no human persecution angle which is directly applicable, are you not asking us to rewrite the treaty itself?
Your Excellencies, we are arguing based on what exists. As if I may point you to an example, the Somalians fleeing the famine were granted refugee status, not just based on the fact that they were fleeing from the famine, but the fact that the authorities to provide them protection were absent or unable to extend such protection. So my argument is that when we try to decipher refugee claims which focus on climate change, we must not look at them in isolation, and authorities and sources for the same exist. So I'm not asking the court to rewrite the law, but recognize refugee status pertaining to the facts in our situation.
Are you asking refugee status on the ground of natural calamity or hazards of climate, or on the ground that your state is not protecting you? Select one out of two.
Your Excellencies, it is a combination of two. As UNHCR states, environmental claims must not be looked at in isolation. That is what we are trying to argue. If we look at it in isolation, then of course it is difficult to extend protection. But given the contemporary times and the prominent displacement drivers are changing. At one point they were armed war and conflict, but now climate change is no longer a theoretical concept of the future. It is happening currently as we speak, and henceforth we must provide a broader interpretation. That is what's being argued. May I continue? To address further, although in the written submissions it has been mentioned unwillingness or unable to protect, that is quoting what, yes, Your Excellencies.
why there is a dispute regarding status of refugee, because you can see that in paragraph number 32, page number 11, you clearly mentioned matter where after earthquake, the support was provided considering them as a refugee. So, what are the factors responsible for that in such circumstances? Is there any cause and effect relationship or what?
Your Excellency, I was not.
My question is very simple. It's climate related matter. Is it required to link the disasters and the suffering of a people?
Your Excellencies, I'm not able to hear you very properly, but from what?
Generally in climate related matter, the problem is that in any violation of private right or any legal matter, you have to prove the cause and effect relationship, right? So what are the factors responsible? Because you have already cited another case, and there the status was considered as a refugee. In this case, you have mentioned that there are repeated disasters, but is there any such link that you can establish that it is because of this disasters, this suffering is there or displacement is there?
Yes, Your Excellencies. So in paragraph number 32, I have given the example of people who were fleeing away from the Haitian earthquake were granted refugee status pertaining to the fact that there was a lack of effective protection coupled with the earthquake. In our case, a landfall hit us, and before recovery attempts could even be completed, an earthquake hit us, destroying most of Nagoya Bati. In such a situation, to expect effective protection from us is unreasonable, as we are already in a situation of distress. Moreover, climate problems with our state is not a new thing. It has been going on for quite some time, pertaining to some human-made factors also. So in such a situation of distress where the prior attempts of recovery were not complete and another disaster struck us by, and now we are in a situation where, as it has been mentioned in paragraph number 7 of the Moot proposition, where our land might be uninhabitable in a few years. In such a situation, coupled with the fact that the state is unable to protect us, the granting of refugee status is not implausible.
Yeah.
Can I continue with my submissions? Thank you, Your Excellencies. The second limb of my argument was environmental collapse can function as a persecution equivalent harm in certain cases. For this, 2 examples I cited through answering the questions of the Somalians fleeing from the famine and the Haitian earthquake. As I've already stated, environmental damage is not to be looked at in isolation, but coupled with other factors that may grant refugee status. Furthermore, UNHCR has stated that the source of disturbance is immaterial, provided things such as state functioning and human dignity are compromised. In the current situation where a disaster has hit us by, the basic means of sustenance itself may be in question. Can we really call this a situation where human dignity is granted to the citizens of Nagoya Bati? And henceforth,
what is the nature of disaster in your case?
It's imminent, given the fact that the island may sink in a few years, and it's gradually and continuously sinking. We are in a position of acute vulnerability, as pointed out by para number 7 of the Moot proposition. May I proceed, Your Excellencies?
If anybody is involved in criminal activity, still he will claim refugee status.
Your Excellencies, the granting of refugee status and detention may be permitted on grounds where a lawful basis is provided, such as criminal activity. However, in the current proposition, what has been stated is a mere allegation. If I may point, Your Excellencies.
Allegation is different.
May I continue, Your Excellencies? Thank you. So the second limb, to sum up, environmental harm is not to be looked at narrowly. Other factors must also be considered, and on the basis of that, refugee status may be granted. Moving on to my third limb, denial of refugee status results in an impermissible protection vacuum. Your Excellencies, as I have already mentioned, climate change is no longer a distant problem of the future. It is currently happening as we speak. There's a protection gap in the international refugee law currently as recognized by UNHCR. It is to be noted that refugee law is a responsive law. If we look at all the instruments prior to the 1951 convention and the convention itself, they address the most prominent displacement drivers of that time, most notably being armed conflict and war. If I may guide Your Excellencies to page 13, para 39 of my written submissions. The convention is a living instrument which is capable of evolution. The same can be seen through the preparatory works of the convention. Recommendation A of the final act, which has already been argued, explicitly leaves out scope for evolution. States have also recognized the need for evolution by acknowledging the protection gap. The African Commission has done this, and instruments such as 2018 Global Compact for Migration. If I may guide your excellencies to page 13 and 14, para 41 and 42 of my written submissions, although there are no substantive judicial cases that have granted a refugee status based on solely climate basis, which we are not arguing in the first place, they still recognize that it is not inconceivable that environmental degradation gives rise to refugee protection in the future under appropriate circumstances. This was held in Toyota versus New Zealand. There are other cases also mentioned in my submissions.
One.
Yes, Your Excellencies.
As far as you are concerned, one of the limbs of argument is that your 968 individuals who were going towards Swazi, their navy intercepted and they have detained them. Now, is it not under their right of the customary international law that if you drift away to a country or the territorial waters of that country, that you can be detained? What wrong have they committed in that? How do you justify the drifting of your people there? And then you are claiming refugee status for them, because their stand is very clear that these refugees who try to come here, they are indulging into all kinds of nefarious activities, and therefore they are not ready to give them the refugee status. Now, how does that impact the international treaties?
Your Excellencies, while it is true that detention can be done on a lawful basis, firstly, here, as the proposition para 8 points out, it is an allegation alleging that some had engaged in criminal activities, and even so, around 1 lakh people tried to reach Swazi, out of which only 8,000 were admitted, and the rest were either deported back or detained. This is automatic blanket detention, which is prevented. General Comment number 31 of the Human Rights Committee mentions that blanket detention solely on the basis that immigrants are trying to reach your country, whether lawful basis or not, is not allowed. Individual assessment must be done, on which our proposition is silent. Moreover, deporting them back to the island triggers non-refoulement obligations under Article 6 ICCPR, and henceforth, while detention is can be done on lawful basis, the same has not been provided in our situation. May I proceed?
Yes.
Thank you, Your Excellencies. So, to sum up my second issue, it is submitted that in light of above submissions, refugee status must be granted to Nagoya Bati individuals, as the refugee definition is capable of evolution. Environmental forces may attract refugee protection, and denying the same would leave a protection gap which it already has. If Your Excellencies have no further questions, can I continue with the second issue?
Yeah.
Thank you, Your Excellencies. My third issue concerns human right obligations that we are claiming Swazi has violated. The first limb, jurisdiction under Article 2.1 ICCPR, arises from effective control. Your Excellencies, rights under ICCPR are not just limited to citizens, rather they arise from effective control. The same has been clarified under General Comment number 31 of the Human Rights Committee. If I may please guide Your Excellencies to page 15, para 45 of my written submission. Nagoya Batti nationals were intercepted on territorial waters and thereafter detained. In Al-Skeni versus United Kingdom, it was held that persons intercepted do not act autonomously, rather under the control of the states that has intercepted them. Moreover, Hirisha, Jama and others versus Italy further clarifies that what matters is effective control. The place of interception is irrelevant. By intercepting them, having the authority to detain them, which it has also, effective control is being exercised and hence human rights obligations are being triggered. It is thereby clear that Swazi's naval interdiction operations created a clear jurisdictional link between Swazi and the intercepted Nagoya Batti nationals, thereby engaging and triggering Swazi's obligations under ICCPR. If Your Excellencies do not have any questions, can I proceed with the next limb? Thank you, Your Excellencies. Moving to then my second limb. Return to life-threatening climate conditions breaches obligations under ICCPR. Your Excellencies, if I may please guide you to page 16, para 48 of my written submissions. The scope of Article 6 of ICCPR, which protects the right to life, extends beyond arbitrary deprivation by the state. It includes conditions that destroy basic means of sustenance. Human Rights Committee has recognized that adverse effects of climate change trigger non-refoulement obligations under Article 6 of ICCPR. Further, it has clarified protection need not be deferred till the moment actual harm arises. Rather, as soon as incompatible conditions with right to life arise, these obligations are triggered and states are required to follow them.
See, Council,
Yes, Your Excellency.
how do you get around Article 2, subclause 7 of the UN Charter? See, because you may be aware that this is essentially a matter of domestic jurisdiction, right? And Article 2, subclause 7 of the UN Charter, it actually grants, a state the power to refuse entry of aliens, right? How do you get around that? These are essentially people who have been affected, by climate laws, by climate change, But for a new state, for a new entity, for a separate entity, these are still climate migrants, right? And this is a matter of domestic law. How do you get around that?
Your Excellencies, while they may have a right on certain grounds to deny entry, again, blanket deportation or detention is restricted, as it has been clarified by Human Rights Committee. So, Your Excellency, do you have?
So if one were to contend that the detention is unlawful, right, and if they are released, right, but see, detention is one part of it, right. The separate argument is grant them refugee status. Now, if one were to even ask the other side to release them, right, one cannot really force a separate state to grant a refugee status, quite irrespective of what the law states, right? What's your take on that?
Your Excellency, non-refoulement is not restricted particularly to refugees. It's a part of customary international law. So even if refugee status is not granted, Swazi cannot send Nagoya Batti nationals back to conditions where their life is being threatened currently, where, as it has been established by Article 6 of ICCPR, incompatible conditions with right to life exist as of now in Nagoya Batti, and henceforth.
Can you take us to the Article 6?
Of the ICCPR? Your Excellency, I don't have an exact reproduction of the
वो
article.
आपको रखना चाहिए, इसमें नेगेटिव मार्किंग हो जाएगा. फाइनल तक पहुंचे हो, किसी ने ये पूछा नहीं. You should have thought of this. You should always be ready with all these conventions, all these things on which you are relying. At least the basic articles. Go ahead.
Apologies, Your Excellencies.
Don't fumble word.
Apologies. Can I continue with my submissions? If I may guide Your Excellencies to page 17, para 50 of my written submissions, Nagoya Batti has been facing climate-related harm for a prolonged period of time, along with state incapacity. And now, coupled with disasters, there is a real inhabitability. I'm so sorry.
No,
Don't worry.
don't fumble.
Yes, Your Excellencies. Warranting protection of international human rights laws. Against this background, Swazi's deportation of Nagoya Bati nationals has exposed them to serious risks under non-refoulement obligations as argued. If I may guide Your Excellencies to page 18, para 54 of my written submissions, Article 9 of the ICCPR prohibits arbitrary detention and requires that any deprivation of liberty be reasonable, necessary, proportionate, and individually justified. Your Excellencies, the facts are silent upon as to whether these detentions are individually justified. All they provide is a claim of a mere allegation. If I may guide Your Excellencies to...
They don't want. As my brother
Yes.
asked you, there is a distinction between detention being lawful or unlawful. Proceed on the premise that the detention is unlawful and you have been able to persuade us on that point. What is the end result of that? The person has to go back, he has to be released from detention and he needs to go back. How does that action fall foul of the refoulement policy?
Your Excellencies, if the
Did you
detention...
get the question? Did you get the question?
You want me to ask you again?
I believe I...
Rephrase it. Detention is one part. If a person's detention is found to be unlawful, he is entitled to be released. Once he is released, he steps into on the land in which he is a foreigner. So what is the end consequence? He needs to be sent back to his country. Correct? Now you are saying that that second part of the action is bad because it offends some policy. How is it offensive? Unless and until you have acquired the status of a refugee, and you have yourself stated that yes, refugee status in general can be granted to the inhabitants, minus those who are found to be indulging in illegal activities, then how do you justify the deportation or refusal to grant permission to stay to some individuals?
Your Excellencies, if the detention is to be found unlawful and then these people are released on that land, again, arguing non-refoulement,
That's okay, don't worry about this.
again, arguing non-refoulement, the conditions currently in Nagoya Bati are unfit for a proper sustenance of life that also has human dignity. No.
You mean to say that there were no people existing in your country now? You're devoid of any human dignity?
No, Your Excellencies, what?
Then why can they not be sent back to your country? Why should this country bear the burden of their staying? They are prima facie said to be indulging in some nefarious activities. You are not ready to accept your people back.
Your
Why
Ex-
should this country or why should we give our opinion that these 968 people should get the refugee status in this country where they have tried to illegally move in?
Your Excellencies, the fact that there are people still living in Nagoya Bati is not enough to altogether state that non-refoulement is not engaged. As the people that are still in Nagoya Bati are not living in conditions that a normal human being who has a proper right to life under Article 6 of ICCPR should exist. Again reiterating, Human Rights Committee has recognized that Article 6 of ICCPR does not just extend to when actual harm has occurred, rather when incompatible conditions with right to life are there. So the people that are currently in Nagoya Bati, although are still living, but they are living in conditions not deemed as having a right to life under Article 6 of ICCPR. Have I addressed your question, Your Excellency? Proceeding. In the current scenario, the detention has been made on an allegation. Moreover, it is also to be noted that the detention must be must be not taking away the liberty of the people completely. Human dignity is still to be assured to these people detained. The proposition, while silent on the facts as to whether this human dignity is ensured, I'll just wind up. Whether this human dignity is ensured, it does state the fact that the detention follows the municipal law of Swazi. However, just conforming to this municipal law is not enough. It is also enough. It also needs to be required that ICCPR's principles are being followed, and the current state's practices centering around xenophobia, political rhetoric that frames refugees as a national security threat, makes it suspectable, and hence we call for investigation in this scenario, and a reasonable inference can be drawn based on the fact that certain people are being deported without even individual assessment. The detention is just on an allegation that this human dignity might be at risk. In light of above submissions, it is humbly submitted that deporting individuals back to Nagoya Batti would pose them to a real threat of life, thereby violating human rights obligations and principles of non-refoulement. Your Excellencies, do you have any questions?
Thank you.
May I proceed with the prayer?
Yeah, please.
Thank you, Excellencies. Wherefore, in the light of questions presented, arguments advanced, and authorities cited, the applicants, the Republic of Nagoya Batti, respectfully request this Honorable Court to adjudge and declare that Republic of Nagoya Batti continues to qualify as a state under international law, notwithstanding climate-induced territory uninhabitability, population displacement, or loss of effective governance control, and retains its full international legal personality, rights, and obligations. Nagoya Battis displaced as a result of climate change and natural disaster qualify for protection as refugees. The Swazi's refusal to admit, protect, or conduct individualized assessment violates human rights obligations, and Swazi has breached its international obligation under treaty law, customary international law, and general principles of international law. Additionally, the court may grant any relief that it may deems fit in light of the above submissions, all of which is respectfully submitted on behalf of the Republic of Nagoya Batti. Thank you, Your Excellencies. It was an honor arguing before this court.
Yes, ma'am.
May it please the court, we are TC22 appearing as agents on behalf of the Republic of Swazi, the respondents in this matter. The agent seeks permission to...
एक minute, team comes.
It's about red.
No, red तो बराबर. Code she said.
22R, right?
22R.
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 The agent seeks permission to address the bench collectively as Your Excellencies and individually as Your Excellency. Much obliged. Your Excellencies, today's case is not about indifference to climate change or the denial of humanitarian concern. It is about the limits of international law. Taking 22 minutes today, I will address two issues. Firstly, that Nagoya Batti no longer satisfies the legal criteria for statehood under international law. And the fourth issue, that Swazi's refusal to transfer climate mitigation technologies does not constitute a breach of its international duties. My co-agent shall address the second and third issues relating to refugee and human rights law, taking 21 minutes, with 1 minute reserved for rebuttals. Unless the court has further questions, I shall dispense with a formal statement of facts. Your Excellency, Swazi is a developed state with a robust industrial base, itself facing several climate-related challenges, including heat waves, cyclones, landslides, and economic strains. While it has invested heavily in renewable energy, flood control mechanisms, and early warning systems, Swazi's economy remains under pressure due to recurring disasters and fiscal constraints. Nagoya Party, a volcanic island situated in a seismically active zone, has experienced environmental degradation compounded by local industrial mismanagement and unregulated activities. Following Typhoon Cedar in 2013 and a major earthquake in 2020, significant displacement has occurred. Approximately 100,000 individuals have attempted entry into Swazi. Given the scale of influx, indeed, given the scale of influx, Swazi has admitted 8,000 individuals while detaining 968 individuals on the grounds of national security concerns. Swazi has also...
Council, I have a question. See, you have admittedly given refugee status to 8,000 of them?
No, Your Excellency, we have not given them refugee status. However, we have provided them asylum for the time being.
Right. On what basis, if you are now contending that it is not a state, on what basis did you grant these 8,000 asylum?
Your Excellency, the question relating to refugees and asylum would be answered by my co-agent.
Okay. But you are still accepting the fact that you have done it, right?
Yes.
8,000, it is your accepted position that they have been granted asylum.
That they have been granted.
And now you are contending that it is no longer a state, right?
Indeed,
Okay.
Your Excellency. If I may proceed to the first issue.
The jurisdiction of this ICJ, you have no jurisdiction, you have no objection.
No, indeed. Your Excellencies, as per Article 34, Clause 1 of the Statute of the International Court of Justice, only states may be parties in cases before this honorable court. The threshold question, therefore, is whether Nagoya Party continues to satisfy the legal objective criteria for statehood under international law. It is respectfully submitted. Indeed.
Are you objecting to the jurisdiction of this?
We're not objecting, Your Excellency.
That runs counter to your argument.
Are you saying that the reference is not maintainable because it is being filed on behalf of an entity which is not a state?
Which is why we are claiming that that their claim cannot be maintained as they're not states under the jurisdiction of the international court. Now, firstly, I would like to address the issue of presumption of continuity that the claimants have put forward. Your Excellencies, as per Article 1 of the Montevideo Convention, there are 4 criteria that the claimants say are essential only for the establishment of the statehood. However, Article 3 of the Montevideo Convention also affirms the declaratory theory of statehood. Under the declaratory theory of statehood, the legal existence of a state is not dependent upon the recognition of other states of its statehood. Therefore, the criteria under the Montevideo Convention are effective and ongoing in nature. If the factual elements cease permanently, then the legal personality cannot be sustained indefinitely. Your Excellencies, the existence or disappearance of a state is a question of fact, as has been articulated in the Conference of Yugoslavian Arbitration Commission, page 81 of our compendium. Thus, as the existence or disappearance is merely factual, once these factual legal criteria they cease to exist, the legality of the statehood cannot be sustained.
But are you admitting, Council, that the territory as on date has not been fully submerged, right? So they have territory. There are people there who are nationals. They are entering into international relations. That's why possibly you also, associated with them and took on board 8,000 people. So on what ground, and I'm at a loss to understand, on what ground are you really questioning the maintainability of this petition?
Your Excellency, we will make 3 submissions. Firstly, that inhabitable territory, which is essential for the territorial criteria to be fulfilled, is absent. Secondly, that the permanent population is no longer present. And thirdly, that there is loss of effective governance. As for the territory, effective governance. Your Excellency, as you pointed out, they have entered into international relations. We as Swazi, we have also entered into diplomatic negotiations with them. However, diplomatic negotiations need not always be with state agents, as multiple states have also been entering into diplomatic negotiations with non-state entities. If you are to take the example of Taiwan, which is not recognized as a state by a lot of other states in the country, there is still diplomatic and trade relations that a lot of countries enter into without formal recognition of Taiwan as a state. When it comes to territory, Your Excellencies, the agent on the claimant side has herself said that the disaster has hit and Nagoya Party is unable for sustenance of its people. The people living in Nagoya Party currently,
In future,
in future, even
not
currently,
in the present.
Your Excellency, even currently the claimant has submitted that the people living there are not living incompatible to the right to life.
But they're still living. They're still living.
Indeed, they're still living. However, the territory, it needs to be habitable and capable of sustaining a community.
It is habitable. It is their case that you can live. If you give us the technology, we will make it better, we will make it habitable. Today, if you don't give us the technology, tomorrow a situation would arise where a person will not be able to live. So they are talking about a futuristic event. You are proceeding on a futuristic event actually occurring and then saying that it has ceased to be a state.
Indeed, Your Excellency, when it comes to the habitation, the claimants have submitted that currently there are people living on, which we do not deny. But this territory, right now, even if there is some landmass above water, this territory is not sufficient for all of the elements to effectively be in one place and to effectively
Give them
constitute
the
a state.
technology, they will be sufficient then.
Your Excellency, this is another fact that has led the court to a misleadment, because the Moot proposition notes that the island is soon going to be uninhabitable. The claimants have submitted that with the aid of our technology, they will be able to reverse the effects of climate change. Your Excellency, climate change is unavoidable. It is irreversible. As the claimants themselves have submitted that it is soon going to be uninhabitable, there is nothing that the climate mitigation could do to reverse. While it could do something to perhaps mitigate, there is no reversal and there is
They
no
have constructed walls, they did everything possible.
construction of walls, Your Excellency.
It is stated somewhere, they have actually constructed walls at some point of time. Sorry, not in this, sorry. It's not in this, it's
Are
in
you,
the other
are you
case.
willing to
Sorry.
give them technology or not?
We cannot give them technology as a form of aid, Your
You
Excellency.
should start with the fourth one first and then come to your first one.
Indeed, Your Excellency. The fourth issue, Your Excellencies, it is submitted.
So sorry, just stop the time for a while. See, we are going to be, since you are dealing with issues 1 and 4. Sorry, since you are dealing with issues 1 and 4, we are going to be asking questions on issues 1 and 4, quite irrespective of the fact, of which issue you are currently addressing. Yeah, for 2 and 3 we'll deal with him. Insofar as 1 and 4 are concerned, so you take it that we have read the facts. You take it that we have seen the Moot problem, right? So irrespective of whether you have to deal with the issues at a later point of time, just please go on answering the questions. Yeah,
Indeed,
thanks.
indeed, Your Excellency. When it comes to the transfer of climate mitigation technology under international law, it is submitted that Swazi does not have any binding obligations to do so. Firstly, the claimants have relied on the UNFCCC framework. Your Excellencies, as per clarifications paragraph 38, both the parties are merely signatories to the UNFCCC framework. Being a signatory does not lead to the arisal of legal obligations under treaty provisions. Even in arguendo, if it was supposed that us being signatories is a signal to be legally bound by the provisions, it is submitted that the UNFCCC framework in itself, the language that it deploys, it does not mandate compulsory technology transfer. The UNFCCC in Article 4, Clause 5, mandates that developed country parties shall take all practicable steps to promote, facilitate, and finance as appropriate the transfer of or access to environmentally sound technologies. Your Excellencies, this obligation is an obligation of conduct, not of result. When it comes to the obligation of conduct, it is an obligation to deploy adequate means, to exercise best possible efforts, and to do the utmost to obtain the intended results. Swazi, Your Excellencies, is already a country that itself is facing extreme climate-related problems. In addition to that, there is an extreme fiscal and economic strain on Swazi as well. Apart from that, there's also a lot of social issues that Swazi is currently facing. Even putting aside Swazi's own problems, Swazi has entered into diplomatic negotiations with Nagoya Party. This has been our best possible efforts that we have put under the UNFCCC framework to facilitate the access of technology. However, it is since these diplomatic negotiations have failed that we submit to the court's adjudication. Thus, it is submitted that even treaties, when they are to be interpreted, they are to be interpreted in good faith and in accordance with the ordinary meaning given to them in context of the treaty's purpose and object. Your Excellencies, the UNFCCC sets out its objective in aspirational terms, seeking the stabilization of greenhouse gas emissions. This provision in itself does not impose specific obligations on individual states. Moreover, there is an absence of opinio juris and state practice, the two constituents of customary international law. Negotiations at successive COPs and other climate treaty conventions have also focused on enhancing voluntary cooperation, not enforcing mandatory transfers, Your Excellencies. In addition to that, Swazi has the sovereign right to regulate its own intellectual property and trade. Nations have a right of permanent sovereignty over their natural wealth and resources, which must be exercised in the interest of national development and well-being of the people of the state concerned. This has been reiterated in the armed activities on the territory of the Congo, page 85 of our compendium. This principle, Your Excellencies, encompasses the state's right to control, regulate, and benefit from resources within their own jurisdiction. Additionally, according to the Lotus principle established in the case of SS Lotus, France versus Turkey, page 69 of our compendium, restrictions upon the independence of state cannot be presumed, Your Excellencies. Sovereign states, they have the right to act in any manner that is not explicitly prohibited by international law. Thus, technologies developed within Swazi's territory are amenable to Swazi's own restrictions and own jurisdiction. Additionally, Your Excellencies, there is the principle of expropriation, which is defined as a sovereign act carried out by a state in which it takes the property rights of a foreign investor. If Swazi were to facilitate this technology and give it to Nagoya Party right now, these terms would be unfair to Swazi as it would lead to expropriation without prompt, adequate, and effective compensation. Your Excellencies, a significant number of investment treaties adopt the standard of prompt, adequate, and effective compensation, also known as the Hull principle. It provides for a compensation in return to expropriation that should be made as soon as the investment is made, an amount equal to the total value of the expropriated investment in a freely transferable and exchangeable money. Industrial properties like patents are subject to the laws of expropriation. Your Excellencies, the UNFCCC requires developed parties to facilitate technology transfer on fair and most favorable terms as under Article 4, Clause 5. This implies a commercial transaction or a mutual agreement, not a unilateral claim upon Swazi's technology. Therefore, Nagoya Party's demand, which appears to facilitate this technology as a form of aid, it implies a transfer without commercial compensation, which would be unfair to Swazi and hence would not lead to the arisen of any legal obligations under the UNFCCC. Additionally, as a final submission under issue 4, Your Excellencies, national security and proprietary interests also constitute legitimate grounds for Swazi to restrict its technology transfer. National security is a well-established exception to international obligations. The General Agreement on Trade and Tariffs provides that nothing should prevent a party from taking any action which it considers necessary for the protection of its essential security interests. Now, while the GATT addresses trade,
What is the security threat that you're apprehending, Council?
the security threat right now is essential security interests. The security right now here is the stability of the nation's economy and the social issues that we are currently facing, gun violence and hate crimes. It is the stability of the internal violence and disruption that is taking place.
Security in the context of you giving the technology to somebody else, how is it going to impair your security, your internal security? You are actually giving the technology to somebody else for their benefit. If they use it properly or if they don't use it properly, how is it going to affect your internal security?
Indeed, Your Excellency. When it
That
comes
is also for environment. You are not supplying military tank or
Right, understandable, Your Excellency. However, when it comes to technologies such as climate mitigation technologies and technology to combat flooding as such, they protect critical infrastructure of the countries that have developed them. They include maps, they include plans of power grids.
Exactly. Sorry. Therefore, under the international law, if these things are such which can mitigate and globally help each other, see, you have gained, you have stopped erosion of certain kind of environmental hazards. See, if you, this is what I feel, if you persuade your government that they may impart with some of the technologies, see, climate adaptation technologies, then maybe the refugees who come from there maybe listen. They can develop their own systems. The fragileness may lessen. It's basically a volcanic type area. Otherwise, a day may come when you have to adopt the entire country.
Your Excellency, when it comes to the facilitation of this technology, Swazi is not putting a blanket refusal that we are absolutely not going to do this. What we're saying is that Nagoya Party's current claim upon this technology is unfavorable to Swazi because this investment, because there has been an investment made in this technology, Your Excellencies.
If they're ready to pay for it,
If they're ready to pay for it on terms that are agreeable to to both of those parties, then that would constitute fair terms and
Then your
favorable.
security threat will go away?
Yeah, no, Your Excellency. What happens with facilitation of technology is that it's done in a form which is not completely openly sourced. There still is selective transfer of plans.
yes,
If I
go
may
ahead,
proceed,
sorry.
Your Excellency.
your tourism might be affected. People may go to them traveling, no?
Well, currently, Your Excellency, the Moot proposition is silent on the tourism aspect and whether
Therefore, it's your
Seni-
ideology. Therefore, see, sorry, good time. See, it's always, I've been telling you, I yesterday also told you in the inaugural session. And questioner may come from the bench for which you should have that presence of mind to answer. See, at times this Moot proposition, let me tell you, because we are in the learning process, and I've told them to stop your time watch.
Indeed.
See, moot courts are such where you are supposed to be groomed for the coming future, you know. So at times in courts, if you have a soft judge like my brother, he may put you very softly. But if you have a bad judge like me, and a question crops up, और आप सर पटक के खड़े रहोगे कि ये क्या पूछ लिया, that is not going to get you through. You should have some answer. Whether it's right or wrong, that will show your presence of mind. This is for all of you sitting there. This is for all of you sitting there. For the future of yours. Go ahead.
Indeed, Your Excellency, in order to address your question.
See, the answer to my question of what would happen, there was a prompt answer. But to my brother, you said the proposition is silent. You could have come up with a new idea which would have got you more marks.
Indeed. If I may address the question now, though, Your Excellency.
Time has gone.
Indeed.
Clear, chup gayi khel. Go ahead.
Proceeding with my submissions, Your Excellency, as we've said, the advanced technologies when it comes to climate mitigation, they protect critical infrastructure of the countries that have developed them. Forced disclosure of this would put the national security interests of the Republic of Swazi at risk. Even if the court were to find prima facie an obligation to transfer technology, which Swazi denies, Swazi's refusal is precluded by the customary international law defense of necessity, as reflected in the Articles on State Responsibility, Article 25, page 40 of our compendium. The defense of necessity, Your Excellency, allows a state to invoke necessity if an act is the only way for the state to safeguard an essential interest against a grave and imminent peril. As has been established, Swazi currently faces incredibly perilous challenges as economic strains, social problems, and climate problems have affected Swazi as well.
So tell me something. Sorry, I'm at a loss to understand this submission. So you are arguing necessity and therefore refusing to share critical tech, right, which may help them either mitigate or adapt to climate challenges, right? Your argument is necessity, right? So how does it protect the argument by just merely sharing it with them, right? Possibly it will come to your aid. If they are able to mitigate climate challenges, it is only going to help you and possibly solve your social problems.
Primarily, Your Excellency, our problem lies with the economic strain that the free transfer of technology would put on our nation. When it comes to the advancement and the development of these mitigation technologies, it requires investments from a large number of proprietors, private companies, and governmental entities. If there is a free transfer without appropriate funding and without favorable terms, then it would lead to a loss of the proprietary interest that these investors have put into these investments.
Right. So your argument is that of proprietary and domestic law, if I've understood it correctly.
Indeed, Your Excellency. These are to protect the security and the national interest of our own people. In the energy sector, and the innovation sector, thus, Your Excellency's patents serve to shape the industry into an industry where we are able to charge prices that are somewhat above marginal cost to again support research and development. This is for the benefit of not only national interest, but the international community as a whole, Your Excellencies. Rather than just creating a monopoly price, it leads to the facilitation of research and development, which is further going to be able to help the development of climate mitigation technologies on an international scale. Accordingly, on the basis of these submissions, Your Excellencies, compulsory technology transfer would erode innovation incentives as well by undermining the patent protection laws. Thus, Your Excellencies, it is submitted that Swazi's refusal to transfer climate mitigation technologies does not breach any international obligations under the UNFCCC or customary international law. It only imposes voluntary best effort duties, while Swazi retains sovereign authority over intellectual property and trade. If the court has any questions.
You can go back to your first one now.
Indeed, Your Excellency. Now, since it has been established that the presumption of continuity cannot sustain the legal status of the claimant's statehood forever, I would now argue that there has been a loss of defined territory, permanent population, and effective governance. Moving to the first submission.
Attributable to you. Also attributable to you, right?
You are one of the cause for it.
Right, correct. You have contributed to the displacement of people in your neighboring territory, right? Is that something that you agree with us or no?
Your Excellencies, Swazi is a developed nation for sure, but the Moot proposition states that it is the political commentators of Nagoya party that have stated that Swazi is the world's biggest polluters.
Yes.
So,
Is that something you're disputing? Yeah, because you have yourself in the beginning of your submissions, you have said that you are an industrialized developed nation.
Indeed. When it comes to the principle of common but differentiated responsibilities, Swazi does have an obligation towards the international community as a whole. However, that is keeping in mind that Swazi has the economic capacity to be able to facilitate and to be able to respect such international obligations. Currently, Swazi in itself is not in a position, even as a developed country, to be able to afford the fundings or to be able to fulfill its international obligations as under the CBDR or any international principles. Your Excellencies, even Nagoya Bati itself, it's through its unregulated industries, through unregulated trawling and waste disposal, has contributed to marine degradation around its own island. Therefore, we're not saying that we ourselves are not responsible or that we are evading any responsibility at all. What we're saying is that any responsibility that we do have is also precluded by our defense of necessity currently, as Swazi is not in a condition to be able to afford the fulfillment of its international obligations. If Your Excellencies are satisfied, may I proceed?
Yes, sir, please. Yes, sir, please go ahead.
Your Excellencies, as has been established, a state needs to be habitable and capable of sustaining a community. Currently, the Nagoya Batians in large numbers have already fled the state of Nagoya Bati. 15,000 residents have been settled in Singland, while more than 100,000 have attempted to come into Swazi. If this shows that the island is on the verge of uninhabitability. Additionally, Your Excellency, there also arises the question of maritime anchors. Maritime zones, as under Article 2 of the UNCLOS, are also part of the sovereign area of the state. However, these zones are ambulatory. They emanate from the low-lying coastal areas. Thus, the normal baseline for measuring the breadth of this territorial sea is the low water line along the coast as per Article 5 of UNCLOS. If the land territory is submerged or reduced to uninhabitable rocks, the baseline from which these maritime zones are established also disappears.
One minute. Only for your advantage. You want to cite any case laws? You have 3 minutes only left with you.
Indeed, Your Excellency. The case.
Marks explique.
Indeed, Your Excellency. The case of maritime delimitation and territorial questions between Qatar and Bahrain, it establishes that the baselines are ambulatory and they emanate from the coast of the area from which the territorial seas are being decided. If Your Excellency is satisfied, may I proceed? Another submission, Your Excellencies, is that the permanent population, which is essential to a state, is no longer possessed by Swazi. Your Excellencies, the permanent population, nationality is governed by national legislation. If the state ceases to exist, the nationality of its people also ceases to exist.
Can you throw some light on Hungary versus Slovakia, 1997?
Pardon, Your Excellency, could you repeat the case?
Can you throw some light on the judgment of Hungary versus Slovakia, 1997? Can you throw some light on the judgment Hungary versus Slovakia, 1997? Have you cited this judgment anywhere?
We have not, Your Excellency. Indeed.
Okay. What? I have few questions, very quick questions.
Indeed.
Can you explain the liability of the state under Kyoto Protocol, Article 10, subclause C, and 11(2)(b)?
Your Excellency, the Kyoto Protocol is not a convention that either of the states are signatories or parties to. Hence, why neither provisions would be applicable to this
And
situation.
what about Article 4.7 UNFCCC?
Indeed. Article 4, Clause 7 of the UNFCCC, it relates to the extent to which developing country parties will implement their commitments under the convention. Your Excellency, it relates to the developing parties and their commitments, not developed parties like Swazi. If I may move forward.
I'll request you to revisit the clause.
You're referring to Article 4, Clause 7 of the UNFCCC.
4.7, Article 4.7, yes. And it's not in page. She should have cited. That is what. It's okay. Go ahead.
Go ahead.
Indeed. Due to the paucity of time and all the submissions having been made, I will now proceed to the conclusion. Yeah. Your Excellencies, again, as we emphasized, we are not indifferent to the suffering of Nagoya Batians. We are just putting forward the limits of international law currently and the conditions under which legal personality and legal obligations arise. Nagoya Bhatti no longer satisfies the objective criteria of statehood.
1 more minute.
Absolutely.
You
No,
have given them also time. 1 or 2 minutes.
indeed.
Sir, please.
Much obliged, Your Excellency. Nagoya Bhatti no longer satisfies the objective criteria of statehood under international law. The presumption of continuity cannot preserve legal personality where territory, population and governance has been irreversibly lost. At the same time, Swazi's refusal to transfer proprietary climate change mitigation technologies does not contravene any binding legal obligations under the UNFCCC or the customary law. International law safeguards both the stability of the state and the principle of sovereign equality. Your Excellencies, it does not and should not authorize the judicial creation of new obligations. Unless the court has any further questions, I respectfully yield the floor to my learned co-agent. Much obliged, Your Excellencies.
Yes,
Greetings to Your Excellencies. I shall be continuing the submission on behalf of Respondent on Issue 2 and Issue 3. The Issue 2 before this Honorable Court is whether the person displaced by natural disaster and climate change qualifies as a refugee under international law. Your Excellencies, we submit that the person displaced by natural disaster and climate change do not qualify as a refugee under international law. We say this for 2 reasons. Firstly, any refugee convention to be applicable on Swazi needed to be signatory to the refugee convention, or the refugee convention needed to be part of customary international law, which both of these are in the present case is not, therefore it is not applicable. Secondly, Your Excellencies, even assuming arguendo that the refugee definitional criteria of being refugee is applicable in this case, even then the criteria isn't fulfilled, so that the people displaced by natural disaster and climate change cannot be considered as a refugee. Your Excellencies, now I'll elaborate on these prongs. Your Excellencies, any law, international law to be applicable on any state, it can either happen through that state is party to that law, convention or treaty, or it is a part of customary international law. As given in clarification number 1, the Republic of Swazi is not party to refugee convention, so it is not applicable on Republic of Swazi through that. And on part of customary international law, there are 2 criteria which outlines that either it should have widespread representation or general state practice, or it is supported by opinio juris, which is also given in Article 38, Clause 1, Subclause B of this court's statute. Your Excellencies, I would like to bring your attention to the case of North Sea Continental Shelf case, which is also given in the our compendium in page number 59. So we have limited number of compendiums, so I'll read the relevant part of that case. Your Excellencies, para number 73 states that apart from widespread practice or general state practice, it should also included that the representative participation of the states whose interests were specifically affected. Your Excellencies, the key word is specifically affected. As Your Excellencies, the countries which host millions of refugees can be considered as specifically affected in the cases of refugee. For example, countries such as India, which has historically hosted numerous number of refugees from Tibet, Sri Lanka or Bangladesh, countries like Pakistan, which host around 1.5 million refugees from Afghanistan, countries like Bangladesh, which host around 1 million of refugees from Myanmar. These countries are not signatories to refugee convention, but still they grant asylum to the needed, they have granted the asylum to needy people. Therefore, it can be said that there is no widespread participation or general state practice of according to Refugee Convention. They don't accept the Refugee Convention, but still they grant asylum to other state people who are in the
So according to you, you want to say that you can grant them asylum but not refugee status. Have I got you right?
Yes, it is on the discretion of the state to grant them asylum status. And I am here in particular this case, I am trying to prove that the Refugee Convention hasn't become part of customary international law, because there is a lot of countries who are specifically affected, but they don't, they are not signatories or haven't ratified the Refugee Convention. If Your Excellency is satisfied with this argument, shall I proceed?
Environmental hazards will not give the status of refugee according to you.
Yes, Your Excellency.
But their human right is not violated by bad environment.
Your Excellencies, that would I be dealing in the next prong as well. But if, as you have asked this question, I'll directly go to that prong. Your Excellencies, as even assuming the Refugee Convention, the definition given in Refugee Convention is applicable in this case, that the Refugee Convention in Article 1, Clause A, Subclause 2 gives primarily three elements which needed to be satisfied cumulatively, which are: there should be well-founded fear of persecution. Second, the displaced person need to have, displaced person is unable or unwilling to take protection or take state protection. And thirdly, the displaced person should be, the persecution should be based on the 5 given grounds, that are race, religion, nationality, being part of particularly social group, and one more. But all the climate refugees does not fall under any of these 3 grounds, Your Excellencies.
See, Council, the law, as you understand, will have to be dynamic. If I can attract your attention to the living instrument doctrine, right, which has been propounded in Tyra versus UK, right? How do you get around that?
Which doctrine, Your Excellencies?
The living instrument doctrine, that the law need to adapt and the law need to be dynamic. They have to be cognizant of the associated conditions. Right here, there are 2 factors. One, you are contributing to, the climate change that your neighbor is really reeling under. And the other is, the fact that the refugee definition is silent. But we are also cognizant of the circumstances, right? And the law needs to evolve. How do you, and also considering the fact that this has been established in other international forums, right? So how do you get around that? How do you explain that?
Indeed, Your Excellencies. The thing here is, firstly, that the refugee definition given in Refugee Convention is exhaustive. So it should be, we are submitting that it should be strictly interpreted. And secondly, Your Excellencies, with due respect to this Honorable Court, this court has an authority to interpret and apply law. But to, if in the future, if we want to include climate people displaced by climate change as a refugee, it is up to international community to make that law. It is not in the parameters of this code, or in the Swazi is also not in the capacity to make these laws. And certainly, as rightly pointed out, that Nagoya Bati is suffering from climate change and natural disaster. So are we, as it is also mentioned in the Moot proposition, para 4. Your Excellencies, if you are satisfied with this answer,
we
shall
answered categorically that we are not rewriting it. We would only be interpreting it to include this. As was informed to you, law is not static. It continues to change. So because of changed times, the drivers or the parameters that were prevailing at that point of time now need to be viewed from today's lens. If we do that, then can we not include climate change as one of those grounds?
Your Excellencies, as this definition is exhaustive in nature, there is no
Then
scope.
read the definition. Please read the definition. Please read the definition.
Your Excellencies, as results, I'm reading Article 1, Clause A, Subclause 2, which is relevant to this our discussion. As a result of event occurring before 1st January 1951 and owing to well-founded fear of being persecuted for reasons of race, religion, nationality, membership of particularly social group or political opinion, is outside the country of his nationality and is unable or owing to such fear is unwilling to avail himself of the protection of that country, or who not having nationality and being outside the country of his former habitual residence as a result of such events is unable or owing to such fear.
Therefore, what my brother is conveying it to you, this is a definition of the early 50s. It was only in 1972 that we thought of environment. It was only in 2004 at the Delhi Convention that we decided that there should be something like climate. So now, giving a narrow interpretation to right of life. See the general remarks on Article 6 way back in 2019 was also broad-based. Right? So what we are trying to tell you is that we may include climate change as a threat to right life. Are we clear? Then go ahead.
Indeed, Your Excellencies. Firstly, this definition has given only these 5 grounds. As you said, there can be liberal interpretation, but there is no scope of liberal interpretation in this particular case. In future, there might be inclusion of climate refugees in maybe new convention or in this exact convention as well. But as of now, it is not here. So, according to the wordings given in this article, we can't include climate refugee and we can't have a retrospective effect of those law.
All right, proceed.
Your Excellencies, further, one point is left. I need to make that as well. Your Excellencies, there is a principle of persistent objectors that is held in fisheries case, which is United Kingdom versus Norway, and also in asylum case Peru and Colombia. Both of these are given in page number 54 of our compendium and 56 respectively, and relevant part has been highlighted. I would read it briefly. Your Excellencies, these...
You don't need to read, just tell us what you're wanting to say.
As these cases held, that deliberate contrary practice by states precludes the formation of customary international law. As there has been, as Swazi in the present case hasn't signed the Refugee Convention, so, and the many countries who even grants asylum haven't signed the Refugee Convention. Therefore, there is a deliberate contrary practice of not following or going according to Refugee Convention. Therefore, it cannot be considered as a customary international law.
Okay, so what you are contending is this, Council, that there are 2 parameters basis which a country can consider granting refugee status. 1, if it's a direct signatory, and 2, if there has been customary law, right? Is that your argument? And you're arguing that since your state is not a signatory and has neither granted in the past, asylum to any country's refugees, right? So therefore, it doesn't apply to you. Is that what you're contending?
Excellencies, for the first part, you are with me.
Right.
But for the second part,
yes,
we also granted asylum to Nagoya Bhatians as well.
Correct.
We are not saying that we will not grant, or we will in future, or in the past we haven't granted the asylums.
Right.
We are just saying that the refugee definition given in Refugee Convention hasn't become the customary international law. So, according to the parameters of the Refugee Convention or the particular definition as well, it is not binding on us, but it is our discretion. If we want in future or in present as well, we can grant asylum on our terms, Your Excellencies.
Okay, go on.
Much obliged, Your Excellency. So, as I have argued both of these prongs, that firstly, Refugee Convention is not applicable on the Republic of Swazi, and further, even assuming even in arguendo, even if Refugee Convention was applicable, the definitional criteria of refugee is not fulfilled. Therefore, the climate change, the displaced people because of climate change and natural disaster does not constitute refugee under international law. If Your Excellencies are satisfied with this issue 2, then shall I proceed to issue 3? Much obliged, Your Excellencies. Moving to issue 3, Your Excellency.
ना कहेंगे तो क्या करोगे?
I'll answer all your questions then.
नहीं ना सिर्फ ना कहेंगे तो क्या करोगे?
Then I'll try to elaborate more and will
Go ahead.
In a lighter sense.
Good.
Justice says that suppose if you say that don't proceed, then we will not proceed. That's what.
No, he says he'll try to convince us.
Convince us more.
much,
Go ahead.
much obliged, Your Excellency. Moving to the third issue, which is regarding Swazi's international humanitarian obligations. Your Excellencies, we submit that Swazi has not violated any of its humanitarian obligation. We say this for 3 reasons. Firstly, Swazi has not breached the principle of non-refoulement. Secondly, Swazi has not violated Article 9 of the ICCPR, which is about the arbitrary detention. Thirdly, Your Excellencies, Swazi has not violated Article 6 and 7 of the ICCPR, which is regarding right to life and right against torture and cruel
Did you
treatment.
read Article 7 for our benefit?
Yes, Your Excellencies. Your Excellencies, Article 7 says, the verbatim, no one shall be subjected to torture or to cruel, inhuman or degrading treatment or punishment. In particular, no one shall be subjected without his free consent to medical or scientific experimentation. Your Excellencies, moving with the first prong of this issue, Your Excellency, that is about the principle of non-refoulement. We submit that the principle of non-refoulement does not impose an absolute or unconditional obligation upon the states, particularly in situation of mass influx threatening the national security and public order. If I may bring your attention to Article 3, Clause 2 of the Declaration on Territorial Asylum, which I'll read for you, Your Excellencies. It says that Article 3, Clause 2, that exceptions may be made to the foregoing principle only for overriding reasons of national security or in order to safeguard the population, as in the case of mass influx of the person. Your Excellencies, as in the present case, around 1 lakh people suddenly in the very compressed time tried to reach Swazi. Therefore, Your Excellencies, even we granted asylum to around 8,000 people. Your Excellencies, as this was the case of mass influx, so we are unable, because we have a limited state ability to absorb people. Therefore, as this is the case of mass influx, we cannot absorb all of these 1 lakh.
Then how did you choose these 8,000 people out of 1 lakh people?
Your Excellencies,
We will give asylum to you, we will not give asylum to why? How did you choose that?
Your Excellencies, 8,000 people reached Swazi. Firstly, we granted asylum to 8,000 people. Then afterwards, around 1 lakh people came. And secondly, the Moot proposition hasn't gave this detail. How did we choose?
डेवलप करना चाहिए, 3 लोगों को बोला. You are the 4th. वो आपको डेवलप करना चाहिए. ये तो इतना अच्छा है कि ये मूट प्रपोजिशन इतना सारा देते हैं। हमारे टाइम में तो इंडिया इज अ कंट्री, इंडिया इज अ डेमोक्रेटिक कंट्री, दिस ब्ला 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 गो, चलो बनाओ अपना। So don't say this that the moot proposition is silent. It is for you to formulate, it is for you to inculcate in yourself.
Much obliged, Excellency. I try to do in my further arguments.
Now go ahead.
Your Excellencies, as I mentioned, that it was the case of mass influx. Therefore, we are not in the capacity to grant asylum to everyone.
Counsel, I have a question. See, the co-counsel argued the first leg of the argument that essentially it's a dead state, right? Nagoya Bhatti is a dead state. It's not. It is not a state in the eyes of law. So therefore, these people in your detention are essentially stateless. I'm just extending that argument. And therefore, under the 1954 Convention, is it not your duty to assimilate them? Because it appears to be an argument of convenience, that on the one side you'll argue that it is not a state, right? And on the other side you're arguing that, look here, I don't recognize these people at all because they have a land to go back to, right? Have I made myself clear? Have I understood the question? Okay.
Your Excellencies, firstly, the basic point that moot proposition clarification is silent about whether we are part of that particular convention you mentioned. Secondly, even if we are considered, even if we consider that they are stateless, Your Excellencies, it's not only our responsibility, because our responsibility is also towards our own people. Your Excellencies, we also need to protect our own people. We also have a situation of instability. Until unless we will protect our own people, we can't be can't be the part of the government itself. Our first responsibility prerogative is towards our own people. So within our limited capacity, we did try to provide asylum to limited number of people. But as this is the case of mass influx, we can't provide asylum to everyone, Your Excellencies. Therefore, we did not. And also one more historical document I want to cite, Travex Preparatories, when this principle of non-refoulement was getting codified in the Travex Preparatories, that numerous countries, like I would quote Netherlands in that case, Your Excellencies, that Netherlands in Travex Preparatories said that Netherlands could not accept any legal obligations in respect of large groups of refugees seeking access to its territories. Your Excellencies, that this principle of non-refoulement was never imagined to be working in the case of mass influx. And we can't force any state in this world to take all of the refugees beyond their capacity, because it would, after a point of time, if we even take, hypothetically consider, even if we take like the people beyond our capacity, the place we are living in, that would be a chaotic place, because we won't be able to provide all the basic needs which are needed by our own population, our own citizens, whom we are firstly responsible towards, then to also the asylum seekers whom we have given the residence.
Do you have any precedent to cite on this? Do you have any case law to cite? Case law in support of what you're saying?
In support of that mass influx, Your Excellencies, as of now, I cannot recall the case law name.
Is there any case? Have you studied it?
I have studied the drafting documents of the principle of non-refoulement, in which it wasn't imagined that it will work in the case of mass influx. That's it, Your Excellencies.
Okay. In fact, there are case laws. There is one Nishimura EQ versus United States, which directly deals with the point. So possibly for your understanding, you may refer to it later.
I'll read through it, Your Excellencies. Moving to the last two prongs of this issue, Your Excellencies. That second last prong is that the Republic of Swazi did not violate rights of the detainees, because firstly, the proper detention should comply with three elements. First, it should be done through the procedure established by law. Second, it should carry legitimate aim. Thirdly, it should be proportionate. Firstly, as given in the clarification number 15, that it was done in accordance to the municipal law of Republic of Swazi. So it was done in accordance to the procedure established by law. Secondly, it carried legitimate aim because we detained those people because they were threat to national security, and also we had fear that they might indulge in criminal activities, and also had that they were involved in the smuggling. Further, Your Excellencies, out of 1 lakh people, more than 1 lakh people, when tried to reach Swazi, we only detained around 968 people. Your Excellencies, that is even less than 1% of all the people who tried to enter Swazi. So it can be said or implicitly interpreted that there was individualized assessment through this, because we only detained certain number of people, which is even less than 1% of the people who tried to reach Swazi.
Where did the remaining go, Council?
Either they were deported or
back to Nagoya Bati.
Yes,
right, which is reeling from volcanic eruptions and also has a clear threat of inundation.
Yes,
right? And you have also equally contributed to that state.
Indeed, Your Excellencies, as in this.
Also, Council, do you agree that your own constitution, it guarantees right to life and liberty to people?
Yes, as it also is given in the Moot proposition.
I'm sorry?
As this is also given in Moot proposition, yes, we respect the fundamental rights of the people. Further, Your Excellencies, though we do respect the right to life of other people, but we are limited by our own state capacity, because firstly, in any country, the first beholder of a right.
Are you taking refuge to Article 33(2) for refusing refugees?
Your Excellencies, as we are not part of Refugee Convention, I didn't use that, but there are supporting articles.
Why do you put it in your arguments? Your argument says that we are relying on Article 33(2).
Also, the principle of non-refoulement is a customary law.
मतलब ये सब आपके teachers ने बना के दिया है?
This is not ours, Your Excellencies.
Okay.
Your Excellencies, this is not my submission which you were referring to.
Okay.
Your Excellencies, further, the principle of non-refoulement, even before it was codified, it was part of customary international law, and we are not disputing that as well. Your Excellencies, if shall I proceed with the last prong of my argument?
Yes.
Your Excellencies, the last prong of my argument is there is no violation of Article 6 and 7 of the ICCPR. Article 6 says that protects the right to life. Your Excellencies, the right to life is Article 6 is applicable for individualized people, not to the group of people. As the Nagoya Bati has largely become inhabitable, and the climate change and natural disaster has collectively affected the whole population of the Nagoya Bati, Your Excellencies, and because of our own limitation and of our own state capacity, we cannot provide or protect that, it cannot grant this right or protect this right to every person, everyone who comes to us, Your Excellencies, because we have limited state capacity, and also we are suffering from economic strain. Our health system has also in dilapidated situation after the natural disaster, Your Excellencies. Further, this concludes my submission on both of the issue. If Your Excellencies have no further question, shall I proceed to prayer? It is respectfully submitted, requested before this honorable court to declare and adjudge, firstly, Nagoya Bati no longer qualifies as a state. Secondly, the person displaced by natural disaster and climate change do not qualify as a refugee. Thirdly, Swazi did not breach any of its human rights obligation given in international law. And lastly, Swazi did not breach its obligation by not sharing climate technologies. It was pleasure arguing before this honorable court.
Thank you.
Much obliged.
Your rebuttals.
Permission to.
Our rebuttals in this regard are two-pronged. Firstly, as the respondents have quoted, the land...
Sorry, Council, just a clarification. Are you going to be giving an issue-wise rebuttal or?
No,
okay.
general
fair,
two
fair.
rebuttals. Okay. The respondents have quoted that Nagoya Batti is bound to become uninhabitable in the near future and that climate change is irreversible. However, still, they refuse to grant asylum or refugee status to individuals who will certainly, according to them, be stateless in the near future. This is a certain violation of Article 6 of the ICCPR. We wish to understand Swazi's position in regards to their statements that are contradictory to their actions. Secondly, their admittance of 8,000 Nagoya Batti individuals is on the basis of an individual assessment. However, there is lack of clarity as to why and how the remaining 100,000 individuals have been detained or returned to the country. We seek further clarifications as to what criteria have been used in these personal assessments. Lastly, just a general clarification for the court, the respondent posed a statement of the claimants in the form of a misleading statement. We wish to clarify that the very fact that we claim that with their technology we may be able to reverse climate harms, we do not intend to mislead the court in any manner. We only propose a mere possibility because the impact of such technology has not been clarified. We only wish to create a certain possibility in the minds of this court.
How do you wish to dispel their arguments on the security of the proprietary information, Council?
Your Excellencies, national security in and of itself is not directly impacted by technology sharing. We understand their concerns about patent protections and that we have sufficiently submitted in our written arguments. However, if more peaceable terms need to be negotiated upon, then we do request for more cooperation and diligence on part of Swazi for us to be able to reach a situation where they can equitably share technology. Such a situation as of now has not occurred. Thank you, Your Excellencies.
Your Excellencies, as claimant said, why we did not grant the refugee status. Firstly, there is no law as such which identifies refugee based on climate change and natural disaster. So
This you already argued. Why are you?
What she is saying is that you liked my face, so therefore you granted me asylum. You did not like his face, so therefore you are not granting him asylum.
No,
That he never answered. That was my question.
Your Excellencies,
You are only repeating
There
what
has
you
to be an
had answered.
objective criteria for you to grant asylum to X and not grant to Y.
firstly, all the asylum seekers were Nagoya Batians. Secondly, that as per Moot prop, the 8,000 people to whom we have granted asylums, they came first, then we granted them asylum, and then afterward, after the natural disaster in mid-2020, then there was surge of 1 lakh more people. So we couldn't accommodate those 1 lakh more people. There wasn't any discrimination per se, Your Excellency.
So you mass rejected them. These 8,000 are not among the 1 lakh.
Yes, Your
वो
Excellency.
पहले जवाब देना चाहिए था ना.
Your Excellency.
जो पहले पूछा. Then it-
Apologies for that.
Okay.
I
No
couldn't
issue, no issue.
elaborate on that. Your Excellencies, apart from that, why that there was second rebuttal was about why did we not grant that 1 lakh people the refugee status, as we cannot give refugee status based on climate change. We have already answered that in our arguments as well. And secondly, Your Excellencies, that we have limited state capacity, which I have already answered in my arguments as well, because of those conditions and of our own economic strain, we cannot grant them refugee status. And regarding Your Excellencies, you had asked the question, how did it poses the national security threat? I would like to answer that. That climate mitigation technologies involves technologies such as radar system, which navigation system, which monitors the typhoons and certain other that volcanic eruption or earthquakes. Your Excellencies, if I may have 20 seconds. Your Excellencies, as these are critical infrastructure of our state, so that it's very difficult for us to share all those technologies which pertains to this category.
All the more reason, Council, for you to share them. Yeah, they will not only help you, right? They will help them, right? So you all, the entire continent will be saved like that, right?
Indeed, Your Excellencies, but we are also, even as a government, we are also bound by our own laws as well. We cannot breach law and then preach law.
Yeah, just as a parting note, Council, your reference is invited to, Toyota versus New Zealand 2020, where the UN Human Rights Committee had observed, and I'll quote, "The committee is of the view that without robust national and international efforts, effects of climate change in receiving states may expose individuals to a violation of their rights under Article 6 or 7 of the Covenant, thereby triggering the non-refoulement obligations of sending states." Right, so.
In that particular case as well, the Court Human Rights Committee rejected the claim of asylum rejected the claim of refugee to that particular person, Iona Tiotio.
Yeah, that was individual. That was
Particular
yeah.
individual.
Here you are dealing with the entire state. That's the differentiating factor. But thank you.
Much obliged, Your Excellency. Pleasure arguing before.
Thank you,
all of us.
thank you, thank you, God bless you. You have 20 minutes to relax till we come out with the results.
What's the time?
I request the entire